The notice of hearing was mailed to both of them May 2nd, 2017.
Okay, I'll find that Ms. Farrar has adequate notice of today's hearing. Please proceed.
And, Your Honor, I would ask that you admit Exhibits A through C. You'll note that Ms. Farrar had been paying her support obligation through August of 2015. She hasn't paid anything since then. And I just have a couple questions of Mr. Falcone, if I may.
Alex here with part 214 of the My Docket series on child custody and visitation. As for my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into the hearing video. It's the final hearing video in this series, the child custody series, and it is over the remainder of the arrearages that my ex owes. I remember being a lot calmer for this hearing, and the only thing that I can really say about why is, in hindsight, I think it had to do with the fact that they no longer had the power to ruin my son's life. Once the court lost jurisdiction over my child, it was a lot easier to go into court. I mean, it's just money at this point. I ended up getting everything that I wanted, which was to collect the new arrearages and to also continue to have a garnishment order on her for the same amount that they were going after anyway. The reason being that I think it was like something around $500 she was supposed to be garnished for child support. And I figured even though she no longer owes child support prospectively, the same dollar amount, $500, should be good enough for, collecting the arrearages. So different purpose, same mechanism. That's kind of how I saw it, and that's what I asked for, and that's what I ended up getting. This is probably the last opportunity that I think I'll have to discuss. No, there's probably one more coming up, but I'll still go ahead and discuss the collection of all of the child support amounts. My memory on this is very fuzzy. I did collect all of it, and I can say with some degree of certainty that I remember there was a few months, a chunk of time, where she started to get garnished out of the blue. It looked like just ordinary paycheck garnishments. And then those stopped. And then after quite a while, all of a sudden we got a big check, several thousands dollars worth. And I think, my suspicion anyway, is that check was her money from the IRS getting seized, like a tax return or something like that. I suspect that she ended up finally filing all of her tax returns just all in one giant lump sum. And I don't know how many years worth of taxes she just wasn't filing because she didn't want me to get the money. But finally, I mean, after the TPR, a few years later, she went ahead and she must have filed because all the money was seized. And that still didn't pay it all off. And then I remember a few more months going by, and then all of a sudden we got a final check for the final amount. And I think my gut is that other check was a voluntary payment. I think that she probably suspected that the tax returns that she filed would have paid it all off. And when she found out it didn't, she got kind of a little annoyed and submitted a voluntary payment to just get, close everything down and just be done with it. These are just guesses, guys. Again, my recollection is pretty fuzzy, but I do recall collecting all of the money that was owed. It just took, years. And it took work. If I didn't do what I did, I wouldn't have gotten, that money. So for all those surgeries, for the student loans that I took out, all that stuff while I was in college, if I was just like, whatever, I don't care, I wouldn't have collected it. And, it's easy to say you don't care when you're frustrated, but really, it helps. The money helps. So I think all that being said, we can now go ahead and take a look at the hearing video.
Sir, can you hear me?
Yes, I can hear you.
Please raise your right hand to be sworn.
Okay.
Do you solemnly swear that the testimony you're about to give in the matter now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I swear. Yes.
Thank you. This is case FV 16-00031 in the matter of Alexander Falcone versus Monica Farrar. We're here today on Mr. Falcone's motion. It's entitled Motion to Amend Judgment with Additional Child Support and Medical Arrearages. He filed a written motion, and based on that, I ordered this hearing because I had questions and I wanted the District Attorney's Office's participation in this. It says that it was served on Monica Farrar at P.O. Box 9508, Reno, Nevada, 89507. I actually don't recall if that was her last known address or if we had a last known address. There was something of a procedural oddity about this case, which was that the case was opened with a notice of intent to enforce and notice of order to show cause in January of 2016, but then the hearing was vacated and nothing further has happened. So this case has been opened since January of 2016, but there's never been a master's findings and recommendation. Is that correct? Ms. Hallahan, to your...
Yes, Your Honor. We've been collecting under the court order.
Oh, okay. All right. So, sir, what we're going to do today, I'm going to hear from Ms. Hallahan of the District Attorney's Office, who will present the case to me. She may have some questions for you, and then she'll give me her recommendations, and then I'll hear from you. I'm going to ask her, though, to tell me first about service of notice of today's hearing on Ms. Farrar.
Your Honor, her last known address is in Hawaii.
Mm-hmm.
She also is subject to an enforcement case out of the Hawaiian Child Support Enforcement Office. The notice of hearing was mailed to both of them May 2nd, 2017.
Okay, I'll find that Ms. Farrar has adequate notice of today's hearing. Please proceed.
And, Your Honor, I would ask that you admit Exhibits A through C. You'll note that Ms. Farrar had been paying her support obligation through August of 2015. She hasn't paid anything since then. And I just have a couple questions of Mr. Falcone, if I may.
So this tells me that this is an evidentiary hearing. One of the things that I wish that the courts would do is clearly mark evidentiary hearings as such. I mean, it's probably something that attorneys are used to figuring out on their own, but when it comes to non-attorneys, I can't always tell. And I've gone through my Docket series, and there were a number of situations where I really wasn't sure what kind of hearing we were going to. But if this deputy district attorney is asking to admit evidence to the court, then this is definitely an evidentiary hearing, because if it wasn't, she wouldn't be allowed to do that. So it's just a mental note for me, and hopefully something for you guys to look out for, because that is an important thing to find out prior to going to a hearing, because whether or not you're going to need evidence is going to tell you how much work you're going to have to do prior to that hearing, and also it's also going to require you to determine whether or not you need witnesses to appear.
Okay. Sir, I'm going to admit these exhibits. Have you seen them? They look like spreadsheets. They're audits that show the payment history for child support, medical cash, and medical expenses going back to December of 2014?
Yes, I have 3. They're not marked as exhibits on my end, so I don't know which one.
Yeah, they're not marked on your end because they were just marked here. A is the child support audit, and it could be that the particular one is different because this one has a run date of June 9th, 2017, so the numbers may be slightly different than what you have. B is for medical cash, and C is the medical expense audit. I'm going to go ahead and admit them, though, so they're part of the court record, unless you have an objection.
No objection.
Okay. Please continue. A, B, and C are admitted.
Thank you, Your Honor. Mr. Falcone, can you hear me?
Yes, I can.
The child support audit, Exhibit A, shows that Ms. Farr owes you back child support, including interest and penalties, of $9,380.27 through April of 2017. Do you agree with that figure?
I agree.
Exhibit B shows the back medical insurance arrears, and that was pursuant to your motion recently filed. The total amount shows $805.19 through April of 2017, which includes interest and penalties. Do you agree with that figure?
I agree.
The medical expense arrearages shows the original judgment that you obtained for $1,663.48. You have also filed a motion to add additional unreimbursed medical expenses totaling $692.42 for a combined total of unreimbursed medical of $2,355.90, not including interest and penalties. Do you agree with that figure?
I do.
And I indicated to you that the District Attorney's Office does not charge interest on unreimbursed medical expenses. Do you agree with that?
Yeah, I would waive those to keep things as simple as possible for your office.
And Ms. Farrar, as I understand it, you have terminated her parental rights, correct?
That's correct.
Have you, do you have a request for how much you believe that these arrearages should be paid back at? What monthly payment?
Shoot, I don't even know. I would ask the court to just order her to pay the arrearages back at the rate of her original child support amount, because even though she's not accruing any new child support, the court, that's the most recent finding that the court has according to her ability to earn income. Mm-hmm. I believe it's 18% of what she was earning when she was working at the VA. So that would just go towards paying the arrearages, and that's what I would ask the court to order.
And is that the $571 per month?
It's $471.
Yeah.
Well, it went down to $471.
Right, then it went down to $446.
I missed that one. I saw that in your audit, but when did it go down to $446?
March 16th of 2016, she was ordered to pay $446.51.
Oh, I missed that one. That's the way I went in the other room yet.
I'm sorry, that's my right.
I wasn't keeping out. That's why we took a recess and I went back to my office to look at these. I was trying to keep track of all the orders and I missed that one.
The original 571.57 from 2014 was reduced in 2015 down to 471.57,
Right.
which was due to Mr. Falcone's relocation to Las Vegas. January 22nd, 2016, the court ordered Ms. Farrar to pay 1/2 of the cost of the insurance premium. That's the medical cash audit. And then March 16th of 2016, it was further reduced down to $446.51 plus
Okay.
half of the insurance.
Okay.
And then her parental rights were terminated in August.
All right.
So, Mr. Falcone, just so I'm clear, are you asking her to repay it at $571 per month?
But that sounds fine. If she has an issue with it and she makes an appearance and she has some reason as to why it needs to be lower, I'm not gonna fight on that. We've stipulated a lot in the past. But since we have no idea what she's earning or where she is, then that's what I would ask the court to order.
Your Honor, and I have no objection to that. I would ask that you divide it $500 to child support, $50 to the medical expenses, and $21 to the medical insurance.
And tell me again where the 2355.90 comes from. I'm having a hard time learning where that. Was that part of
I
that
think
motion?
Mr. Falcone can better address it, but there's a judgment for $1,663.48.
Right.
And then he filed a motion to adjudicate an additional amount of medical expenses.
Right.
The additional medical expenses were $692.42, and they're in one of the exhibits that he provided to the court. As you might recall, the district court judge denied his motion to amend judgment with leave to resubmit it in this child support case.
Right.
So the $692.42 is just additional.
Oh.
reimbursement.
So that totals the 2355.90.
Right.
Okay, I got it now. Right. So, sure, what I'll do then is I'll order that through April, the child support arrears are $9,380.27 to be repaid at $500 a month. The medical cash arrears are $805.19 to be repaid at $21 a month. The medical expense arrears are we will add the $692.42 in unadjudicated medical expenses to the already adjudicated arrearage of $1,663.48, which, while I trust Ms. Hallahan's math, I want to do this myself. 1663.48 plus $692.42. Totals $2,355.90 in medical expense arrears to be repaid at $50 a month. There is no ongoing child support amount. Payments to be by wage withholding. The state of Nevada has continuing exclusive jurisdiction. So do you understand all of that, sir?
Yes, I understand.
Is that satisfactory to you?
That is satisfactory.
And Ms. Hallahan, is there anything further that we need to discuss?
No, Your Honor.
So that's all we needed to do. That will conclude this hearing. You'll receive a copy of the order from today's hearing at your mailing address. And we'll conclude this hearing at this time.
Okay, thanks.
You're welcome.
Just a few ancillary documents to go over. We have the hearing master's findings and recommendations. This is, it looks to be some kind of standard document that got output indicating that I was present telephonically, representing myself, that my ex did not appear, and that they are retaining exclusive jurisdiction. If you want to learn more about that, watch my video on the topic jurisdiction. Make sure it's the high conflict child custody version because there's a couple in the legal nuts and bolts, and that's not the one I'm talking about. Judgment is entered against my ex for these dollar amounts. Wage withholding shall issue immediately. There's already one issued. This is just basically continuing it. My ex is responsible for all the payments due under the order, and let's see, it's just telling her how to pay, like through, I guess they call it SCADU, S-C-A-D-U, which is the State Collection and Disbursement Unit. I think all the states have some kind of version of this. Interest is going to be assessed at the legal rate with a 10% penalty, which is good, and that a judgment is entered against her for cash and medical, for cash medical arrearages, and you can see the dollar amounts here. And it just is a basic, like I said, guys, it's a form order that just goes over, for the most part, money, how to pay the money, and stuff like that. Nothing really jumps out at me as worthy of looking into. These child support orders are just kind of like, you know, bills. It's just a big giant bill that they're going to hit her with. Don't see anything else here of interest. We have the minutes, and this looks different. I've never seen minutes like this before. Usually they're typed up. So it just looks like they took some notes on the dollar amounts that were owed. And what is this here? So they did an audit. Apparently the Child Support Enforcement Division did an audit. I'm not too interested in spending a lot of time on this, guys. This is not a legal document, so feel free to go look through it yourself. And if you happen to see something that jumps out at you, you have a question on it, go ahead and mention down in the comments below, but not really a legal document. It's just like a ledger or an accounting statement of all the money that's owed. And that's that. Certificate of mailing, indicating that what is this here? Indicating that the findings and recommendations were mailed to both myself and my ex. Here we have another set of findings and recommendations. What is this? Is this the same thing? Looks like they filed it twice, guys. It's the same document. I don't see anything different. Oh, well, this one doesn't have those exhibits attached. Okay. Next, we have certificate of mailing. Again, probably indicating they sent the other findings and recommendations to my ex as well. Oh, no. I see what they did. Okay, so the second one they sent to the Child Support Enforcement Agency in Hawaii. The Child Support Enforcement Agency in Hawaii never did anything. They couldn't find her. So I guess they're just sending the Hawaii Enforcement Division a copy of this as well, which it doesn't matter. Nothing comes of it. Notice of change of address. Here I am indicating to the court that my address has changed. If you want to learn the importance of filing the notice of change of address, please watch my video on the topic notice of change of address. I cannot stress that video's importance enough. If you haven't seen that video by this point in my docket series, you need to watch it. Next, we have the satisfaction of judgment. This is me indicating that the entire amount was paid off. If you want to learn more about this document, I do believe I have a video on the topic satisfaction of judgment under the legal nuts and bolts category. Next, we have the release of judgment lien, which is the district attorney, I guess, doing the same thing that I did with the satisfaction of judgment, only they have a different name for it. Interesting. Which makes sense. In fact, it's possible that I didn't even need to have the satisfaction of judgment in this case. It's possible. And then they're indicating that they sent the release to both myself and my ex. Last, we have the withdrawal of appearance, and this is the district attorney's office stepping off of the case, and they are no longer involved in the case. And this is them indicating that they are sending this notice of withdrawal to both myself and my ex. Going into the aftermath, I filed, it looks like 2 documents. They were free filings, so I incurred $0 in costs. My ex didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex didn't have an attorney, so she incurred $0 in attorney fees as well. The government, specifically the District Attorney's Office, filed, it looks like 1, 2, 3, 4, 5. Yeah, 5 documents. They were all free filing, so the District Attorney's Office incurred $0 in costs. They would have had to spend some time reviewing the findings. I would say 5 minutes. It's a form finding. Let's see here, the minutes again, 5 minutes, so we're at 10 minutes so far. Both of the certificates are negligible. Notice a change of address to put it in their computer system, 5 minutes, so we're at 15 minutes so far. Satisfaction they would have ignored. The notice of withdrawal and the release of judgment, for them to prepare those documents, I think it would be fair to round them up to a total of 30 minutes for all of these documents, which at the rate of $250 an hour comes to, wait, they would have also had to participate in the hearing. So we're looking at $125 in attorney fees just for the documentation. I think to participate in the hearing, I would say 30 minutes. So that's going to come to a total of 45 minutes in attorney fees, and that's going to come to a total of $375 in attorney fees for the District Attorney's Office. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.